Good morning, everyone, and welcome to day 2 of the Nuremberg Forum 2025. Whether you're joining us here in Courtroom 600 or online, a warm welcome. We will now have the first of our panel discussions for this year's forum, which will be moderated by my colleague, Ms. Darleen Seda, who will be joined on the panel by Professor Neha Jain, Professor William Schabas, and Professor Gerry Simpson. Ms. Seda is Senior Officer for Capacity Strengthening and Training at the Nuremberg Academy, in which capacity she leads all our capacity strengthening work, which is held both here in Nuremberg as well as worldwide. Thank you, and I hand over to the panel now.
Thank you. Good morning, everyone, to the first panel of the Nuremberg Forum, where we're going to explore law, state, and individuals. It's rather a gloomy morning, but I hope that the discussions we're going to have today are going to warm us up a little bit. The panel will revisit a question at the heart of the Nuremberg legacy. How has international law evolved to hold individuals accountable while trying to balance and respect state sovereignty? 80 years later, what does this balance look like in theory and in practice, especially as new conflicts, courts, and claims of immunity continue to test it? The Nuremberg trials marked a profound turning point. For the first time, leaders were held criminally responsible not as abstract representatives of the state, but as individuals accountable to the international community. 80 years later, the Nuremberg principles remain foundational, yet they are under enormous strain. The global order is witnessing renewed contestation of multilateralism, escalating international crimes, proxy conflicts, and the emergence of new technologies that challenge our legal frameworks. If the Nuremberg principles envisage that no one stands above the law, what would it look like today in conflicts like Ukraine, Gaza, Sudan, DRC, and many others, to make that principle real for sitting leaders, not just for those who have lost power? In our discussion today, we will explore 4 interlinked themes: the historical evolution of international criminal law foundational norms since Nuremberg, the unresolved tension between state and individual responsibility, immunities, and the role of the Genocide Convention in shaping contemporary international criminal law. I'm honored to be joined by 3 outstanding scholars who definitely do not need an introduction, and I'm aware how ironic it is to say they do not need introduction, but still go on to introduce them. So I will briefly introduce them, but you can, of course, read the extensive biography in the brochures that you have been provided for. I will start with Professor Neha Jain, who is a professor of law at Northwestern Pritzker School of Law and Deputy Director of Northwestern University's Buffett Institute for Global Affairs. Before that, she served as Professor of Public International Law and Co-Director of the Academy of European Law at the European University Institute. Ms. Jain is also a permanent visiting professor at the Danish National Research Foundation's Center for Excellence for Global Mobility Law at the University of Copenhagen. She is a member of the editorial boards of the American Journal of International Law and the European Journal of International Law. Welcome. Professor William Schabas is Professor of International Law at Middlesex University in London and Emeritus Professor at Leiden University and University of Galway. He's also a distinguished visiting fellow at the Paris School of International Affairs and honorary chairman of the Irish Centre for Human Rights. And he has, as we all know, extensively and widely published on matters human rights and international criminal law. Last but not least, Professor Gerry Simpson is Professor of International Law at the London School of Economics. He's also taught at the University of British Columbia, the University of Melbourne, and the Australian National University, and has held visiting positions at Sydney Law School, Harvard Law School, and New York University. As Professor Schabas, also widely and extensively published on international law. Welcome. So for the next 1.5 hours, we are going to discuss law, states and individuals. We're going to have a 1-hour discussion before opening the floor to questions from our audience in person and online. With that, let's begin our conversation by looking at the trajectory of international criminal law since Nuremberg. And perhaps I can start with you, Professor Gerry Simpson. You have all allowed me to call you by your first name, so I will continue that way. The Nuremberg trials redefined the relationship between law, morality, and state power. And since then, 8 years later, we've seen a proliferation of tribunals and courts. We have seen the introduction of the UN as an organization. Yesterday, we had a lot of discussion on the mandate of the UN Security Council. Despite this development, reflecting from the origins of international law, where do you see, how far have we come, and where do the ruptures still remain?
Really good question. And thank you so much for inviting me here, Christophe, Viviane, Kieran, and your team. I'm sorry I wasn't here to hear the discussion yesterday afternoon. I was stuck on the German rail network for several hours. So I'm delighted to be here. And this is an important question. So I think I'd like to start by just noting something about the international criminal law order such as it is, and it's something I emphasize to my students when they arrive, around 40 of them each year at the London School of Economics to study this subject, and that's its newness. I mean, it's only been around for, I'd say, just over 100 years. In fact, I sat in this very room being interviewed by Viviane just after I gave a paper called 100 Years of Turpitude, which was about that era, I think it was from 1917 to 2017. So it's a system that has been built more or less from scratch, and I think it should be judged accordingly. It even felt like an unlikely enterprise in 1945. As Winston Churchill said in 41, we're in the presence of an unnamed crime. We're in the presence of an unnamed crime. And I'll finish my comments with something about the transformation in language, but it's striking that we didn't even know what to call these atrocities back in 1941. And in 1945, there was a survey of a group of Americans, the average Americans, about what they wanted to happen after the Second World War. And only 2% of them felt that there ought to be trials of the leading Nazis. I think 8% favored torture, and many more favored summary execution. So it's an achievement that we're even here discussing 80 years later, the achievement of the Nuremberg War Crimes Tribunal. I just want to speak about briefly 3 or 4 developments in the sort of post-Nuremberg period. So on one hand, Nuremberg and Tokyo, and in fact we had a conference here a few years ago about Tokyo. I'm now referring to this dual period as Tokyo-Berg, but initially after Tokyo-Berg, the 2 great trials in Tokyo and here, there were no institutional developments. There was no permanent Nuremberg tribunal, no permanent Tokyo War Crimes Tribunal, no International Criminal Court. As we know, discussions broke down in the 1950s, largely because of the onset of the Cold War. So to that extent, we can think of the period immediately after the trials as a relatively fallow period. But there were several developments I do want to mention, and I'll take them very briefly. The first is that the norms at Nuremberg were in effect internalized, or international criminal law that went domestic. When Tim McCormick and I edited a book many, many years ago about domestic and international approaches to international law. We were just amazed at how many domestic approaches there were, how many trials there had been, for example, in national jurisdictions around Europe in the 1950s and 60s. So though there was no new Nuremberg court, there were a lot of national courts applying the Nuremberg principles. Secondly, there were a number of what we might think of as definitional projects. So the international community was much more engaged in trying to work out what these crimes enunciated but perhaps under-elaborated at Nuremberg actually were. So in the late 1940s, we had, of course, famously, the Genocide Convention in 48, the Geneva Convention in 49, and then the additional protocols in 77. So there was a lot of what you might call, legislative work after the initial institutional developments or origins of the system at Nuremberg. And thirdly, there was a shift in what I would call the atmospherics of international law away from sovereignty towards what Theodore Meron called the humanization of international law, an attention to the rights of individuals, the rise of the human rights movement, and a belief that what states did to their own citizens could, for the first time, be opened up to some sort of scrutiny. So I think this shift from sovereignty to internationalism, though it can be overstated, was undoubtedly one of the immediate and indeed long-lasting legacies of the Nuremberg Tribunal, and in particular, one of the categories that we'll discuss a great deal today, no doubt, crimes against humanity. Then we have a move towards not so much definition, but from institution to treaty, and a sense that these treaties, the Genocide Convention, the Torture Convention in particular, could sort of shift responsibility for international criminal law and the enforcement of international criminal norms from the international level or from international institutions, which after all didn't exist at that point, to domestic jurisdictions and domestic courts. So we moved, if you like, and again, this is a very broad brush description, from international jurisdiction to something called universal jurisdiction, which again, we will probably discuss at various points. But the final point I want to make, and I think it's the most important, is that we now live in a Nuremberg world and we speak Nuremberg language. And this is a radical and dramatic transformation in the way we think about, speak about, and therefore act in relation to international events, wars, and atrocity. Whenever we hear anyone discuss Ukraine, Gaza, Sudan, they talk like international lawyers. They talk in this entirely new language. They talk in a surprisingly legalistic and technical manner. I walk my dogs on Hampstead Heath in North London every morning, and I often hear people discussing what looks like international law 101. They'll talk about crimes against humanity or breaches of the UN Charter, or I overhear that Vladimir Putin has committed a crime of aggression. It's worth remembering that no one spoke like this in 1914. There were completely different languages available then, and those languages, which might have been about working class solidarity or the sort of poetic language that emerged from the First World War, have in a way been sidelined by the move towards a form of legalism. So I think Nuremberg's greatest or biggest legacy is that we now all talk like lawyers.
Quite fascinating interaction there. And I think I agree, it's good to hear you saying that being here today in 2025, it's in itself an achievement of the Nuremberg trial. If I may turn to Bill, you have written quite extensively on Nuremberg and the Nuremberg legacy. Do you think that the original vision of the Nuremberg trials and the Nuremberg judgment has been achieved 80 years later?
thank you. And thanks, Christophe and Kieran and the others, and yourself, Darleen, for inviting me here once again to speak in this hallowed room and at this hallowed podium. Gary began with a quote from Churchill, and I have a little quote from him as well. It's not a vulgar one. There are plenty of those. Churchill didn't like the idea of a trial at all. And he was opposed until the very last. He opposed it until the very last minute, when the British finally gave in at the end of April, 1945. There's a note that he wrote to the cabinet that's in the British archives, where he says that trials are not a good idea. He has a phrase that I love. He said, "We want to avoid, quote, the tangles of judicial procedure." By summary execution. That was what he wanted to do, and they actually prepared lists of people to be executed when the war was over. Well, of course, this is the room of tangles of judicial procedure, and we can thank Robert Jackson and Aaron Trainin and some of the others for ensuring that that's what happened here. I haven't written that much about Nuremberg, although I still would love to write a book on the subject and might do it at some point. One might think that the literature is so large. In my own personal library, I have probably 2 or 3 meters of books about the trial, not just as well as the proceedings, of course. There's a brand new book just out in France called Crépuscule des Hommes. And it's kind of a half fiction, half narrative account of the journalists at the trial, the goings on here in this building, at the Grand Hotel, and of course at the Faber-Castell Chateau, where they all stayed and where all kinds of interesting things seemed to happen. And the book is on the long list for the Prix Goncourt, the most prestigious literary prize in France. So there seems to be no shortage of things to still to be said and written about it. I think Sylvia Fernandez yesterday pretty much said it all in her speech, actually. I don't know what we could add meaningfully to the assessment. And it was a mixed evaluation, because she pointed to the shortcomings and the flaws here, the weaknesses, we could say. Another quote from Georges Clemenceau, the French premier at the end of the First World War, and he was involved in the very initial discussions about setting up a tribunal at the Paris Peace Conference. And he in answer to Woodrow Wilson, who didn't want to set up a tribunal, he said that the first tribunal must have been summary and brutal, but that it was the beginning of a great thing. So I wouldn't describe Nuremberg as summary and brutal. I think it had its flaws, but it's actually a rather extraordinary achievement. We all know how hard it is to do now. Many people in this room have devoted big parts of their lives to making international justice work, and it remains quite miraculous what they were able to achieve in so short a time and with no experience to draw on in doing it. Let me just conclude by going around to the other end of it and taking reflecting on the latest initiative in international justice, which is this proposed ad hoc tribunal for aggression in Ukraine. Agreement was reached in June between the government of Ukraine and the Council of Europe, and we have a statute, and now they're waiting to see who will sign on and who's going to ante up the money for it, which may be the big question. There may be some enthusiasts for that tribunal in the room, but I'm not one of them. I think it's a retreat from Nuremberg in a way. When Philippe Sands made his famous call to set up the tribunal, he said we should have a Nuremberg-like tribunal. But Nuremberg was better in a way, because Nuremberg asked the judges to rule, asked the prosecutor, first of all, to bring the evidence that crimes against peace had taken place. It didn't say by whom, and the judges were then to rule on whether they'd taken place. It seems to me that the tribunal for aggression against Ukraine has kind of already decided what the crime is, and they're just leaving it to identify some little cohort of people between those who are going to get effective immunity from the proceedings, the troika, and those who bear the greatest responsibility. That phrase is used as well. I don't know who they're talking about, but it must be a pretty small number. And, you know, it strikes me they have not built on the experience we have with setting up a similar type of institution, a special tribunal for Lebanon. The plan is, and they say they need enough money for 3 years. Is there anybody, and there's a lot of experience in the room, is there anybody in the room who thinks it could be done in 3 years? Is that possible? And we're talking about a tribunal that will try people who aren't there. To me, it's just going to be a big, expensive moot court with one difference. With one difference between a moot court and a tribunal is that in a moot court, either side can win. Actually, I've been a judge in many moot courts, and you don't know who's going to win until you hear the lawyers, whereas I think I know who's going to win and who's going to lose in the special tribunal for their aggression. The reason we have it, of course, is because the institution that, again, Sylvia described so eloquently yesterday as having been created to improve upon the past by having an independent prosecutor and removing or at least weakening the political factors that influence the selection of situations for prosecution. And we're doing the exact opposite there. And so I hope they don't raise the money, frankly. And maybe they should be more realistic about how much money is required, and maybe it will die a natural death. But one would be inclined to say that comparing the two ends of this timeline, 1945 to 2025, that in some ways we're going backwards.
Quite fascinating reflections, and I think you also bring about interesting points, immunity, which we're going to come back to very briefly. But before we move on to the next theme, Neha, in your experience, how do you think the evolution of the Nuremberg norms has changed the context of international criminal law today, as you know it, especially considering you've also written quite extensively on individual criminal responsibility? How do you see it having changed from 1945 to date?
Thanks for that, Darleen, and thank you, Christoph, Vivian, Kiran, for the invitation. As always in Germany, it's good conversations, good music, as yesterday, and good food. So I think we're all very lucky to be here and to be part of the panel. So I want to continue a little bit along the themes that Gerry and Bill have raised. I'm not going to quote Churchill because I'm from India, which is a former colony of England, so I'm not going to quote Churchill. But as Gerry said, so the system was not just built from scratch, it was also built on destabilization and disruption. And today, as we heard so eloquently yesterday, there's a new kind of disruption and a new kind of destabilization, where there's a profound crisis in this idea that you raised, that we're all accountable to international law. But at the same time, probably demands for accountability, as Gerry said, have probably never been so acute, not just in our small community of international lawyers, but also in the lay public, as you see in protests, as you see just kind of walking on the street. And these demands are not just from criminal institutions, but courts like the ICJ. So the ICJ, I mean, to observers of the court, this is nothing sort of astonishing. In the aftermath of the Southwest Africa cases, the ICJ had completely fallen out of favor. Some scholars said that, in fact, things were so bad that judges were having to engage in ambulance chasing to try and get cases to the court. And whereas now the ICJ is back in style, it's now adjudicating cases of self-determination, climate change, and of course genocide and aggression. And likewise, the ICC2 is very much in the public eye. Normal people, Uber drivers talk about the ICC if you take a ride in a taxi. And so this is really, really astonishing in some ways in terms of the evolution and the context. And I think the charged context and just how polarized these proceedings are is also important for us giving a scorecard, so to speak, to the Nuremberg norms and how well they have aged. And are our crises the same as the ones to which Nuremberg was responding? And do we need a different vision of the world order compared to the one that Nuremberg so painstakingly built? And I have two thoughts on that, which is inspired in some ways more by the spirit of Nuremberg, which I think is a call to not be complacent, as the Undersecretary General emphasized yesterday, but also bold in our vision for what the future world order should look like. The first concerns core crimes and how we think about core crimes. And the second, I think, relates to the vision of international community that was developed at Nuremberg and whether that vision still stands today and what we want it to look like for the future. So on the first issue of core crimes, Nuremberg gave us, was instrumental actually in establishing what counts as the kind of conduct for which we must have accountability under international law. And there's very little dispute that we now have these 4 core crimes, even though their definitions may have evolved since Nuremberg. But the question is, are there other forms of conduct that should equally shock the conscience of mankind? So for example, some would argue that just as the biggest threat to our lives at the time of Nuremberg was our politics gone cancerous, in David Lubin's evocative phrase, is the biggest threat to our times today the destruction of the planet. So if climate change, biodiversity loss, the destruction of ecosystems are amongst the top risks facing the planet today, then should they be included in the list of core crimes? And going even further, just as Nuremberg elevated the individual as a serious subject of international law, should we elevate nature as a serious subject of international law going forward? And in many ways, this is not a hypothetical situation. You have very, very strong calls and demands, for example, for the crime of ecocide to be the 5th core crime in the Rome Statute. Again, these demands don't come just from international lawyers. They come from lay people in all walks of life. They come from celebrities, and they come from political leaders. And you have various domestic jurisdictions that now have placed ecocide on their books. And in parallel, you have courts like the Special Jurisdiction for Peace in Colombia, which has recognized, again, territory as a victim in its own right. And in the process, it's championed an indigenous cosmovision, and which can be integrated into accountability for what we consider core crimes. And so I think these developments raise really foundational questions about who is the proper subject of international criminal law today, and is it possible to have a vision of international criminal justice built on the edifice of Nuremberg, but a vision that is more decolonial, that is more locally sensitive to different visions of justice being championed in different parts of the world. And this brings me to my second point, which is that I think these developments raise the question of should the next version of the Nuremberg principles be responsive to how it thinks about inclusion and exclusion. So as Judge Fernandez said yesterday, Nuremberg often had to face the charge of victor's justice, even as it sought to develop universalized principles that are of concern to the international community as a whole. But today, as scholars like Fleur Jones have argued, we see renewed interest in the articulation of community interests by, for example, states such as Gambia, Nicaragua, South Africa, mostly in the ICJ litigation concerning state complicity in the commission of serious crimes. But these applications seem to be less about the Nuremberg version, the Nuremberg universalized sense of community, and instead they seem to be more about reinforcing and demonstrating political allegiance, political allyship. And so in other words, the sense of community or the reference to community, especially by global South states today, does not actually presuppose a unified sense of international community. Rather, the vocabulary of community interests is a way for states and individuals to articulate why they should have a stake in what is ostensibly a bilateral dispute. So this, I think, is an opportune moment for us to also think about how we conceive of community or international community in international criminal justice when it comes to questions of justice, not just through international criminal law, but through international law writ large.
Thank you very much, Neha. I think you also raise quite pertinent questions. Who is the proper subject of international law today, especially seeing how there is parallel proceedings before the ICC and the ICJ? And maybe that also naturally brings us to the next theme of state versus individual responsibility. Nuremberg asserted that crimes against international law are committed by men, not by abstract entities, and only by punishing individuals who commit such crimes can the provisions of international law be enforced. Yet public international law continues to hold states responsible for international wrongful acts. We've seen this in cases before the ICC in Ukraine, in Gaza, in Sudan, in Myanmar, where there is parallel competing proceedings before the ICJ with the states, but also investigations against individuals in these scenarios that I've just mentioned. Neha, if I can ask you a follow-up question after your intervention, given the overlap of ongoing investigations before the ICC and proceedings before the ICJ, do you see a functional bridge between these systems, or are they destined to be parallel?
So I think that's a really interesting question, because international law historically, of course, has said that there is no problem here, because international law historically has just bifurcated the responsibility regime. So the Rome Statute specifically says that whatever it says has no bearing on the question of state responsibility. The draft articles of state responsibility say the same thing on the other side of the coin, that whatever you say about state responsibility has no bearing on the question of individual responsibility. But now, as you say, we have all this parallel litigation. I think it's going to be impossible in some ways for example, the ICJ to pronounce on state responsibility without getting into questions of individual responsibility, and vice versa. So I think we already in some ways had a preview of that in the Bosnian genocide case. So as most of you, probably all of you in the room will recall, this was a case before the International Court of Justice. Bosnia and Herzegovina had alleged that the Federal Republic of Yugoslavia had provided political, financial, and military resources and encouragement to its agents and to its surrogates, including the Republika Srpska, to facilitate genocide in Srebrenica. And so the ICJ was seized of a matter on whether the FRY was responsible under the Genocide Convention for the alleged genocide which was perpetrated by the Republika Srpska. And even though the treaty in question was the Genocide Convention, the ICJ relied very heavily on the draft articles of state responsibility for the rules of attribution and the responsibility that Serbia bore, both direct responsibility but also responsibility as an accomplice. But if you look at the separate opinions in that judgment, it's not at all clear that the ICJ could have rendered its judgment on state responsibility without all the prior work that had already been done by the ICTY in terms of evidence gathering, fact finding, etc. So, for example, Judge Benuna has its separate opinion, which also stressed that the court was characterizing the crime committed at Srebrenica as the crime of genocide, being entirely reliant on the ICTY's judgment in the Krstić case. And so there's a question here about whether or not the ICJ is able to rule at all on questions of state responsibility in the absence of the kinds of resources that were put into the fact-finding and evidence-gathering process at the prior criminal institution, which in this case was the ICTY. And so I think the question has become whether the ICJ has created a relationship of dependence, where it will always have to await and defer in some ways to the decision of a criminal mechanism before it can pronounce on attribution specifically. And now this is far from a hypothetical scenario because you have the same factual situations before the courts. But at the same time, in the ICC's case, in some of these cases, it will actually be really difficult to get some of the accused before the court in the dock. And so you could have a situation where the ICC is paralyzed because it's unable to get the accused in the dock. And at the same time, you have the ICJ waiting for a decision by the ICC or by some other criminal mechanism before it can say anything about attribution. Whereas conversely, you now have the ICC, which might struggle to operationalize the crime of aggression in the absence of a prior determination by something like the ICJ on whether the conduct in question actually counts as aggression. So because, as various scholars have said, you need a determination on whether there's a violation of the UN Charter or the territorial integrity on sovereignty of another state. And so then the question becomes whether the ICC will actually have the competence to address an issue that is directly one of state responsibility, even though the ICC's mandate, of course, is confined to individual responsibility. And can it avoid that determination if it rules on questions of aggression? And if the ICC does that, if the ICC does make a ruling, will the ICJ just ignore it and say that, well, actually, that was for the purposes of individual responsibility, we can choose to rule differently? Or will the ICC limit itself, saying we don't want to encroach on the jurisdiction of the ICJ, and so whatever we say is only confined to criminal responsibility? And the ICC has done that to some extent in the past. For example, we saw that in the case of Palestine. So when the ICC had to rule, the pretrial chamber had to rule on the question of whether or not Palestine would qualify as a state on the territory of which the crime was committed under Article 12. The ICC said, well, whatever we say on this issue has nothing to do with the question of Palestine statehood under general international law. This is merely for the purposes of determining our own competence. But that decision was criticized quite heavily in some of the academic commentary, saying that is there now like a special statehood for Palestine just for the purposes of the Rome Statute, which has no bearing on general questions of statehood. So I think how the ICC approaches issues that implicate general international law and that are very much in the jurisdiction of the ICJ is a live issue for both courts. And it's actually likely to become more so as you see both courts handling the same issues.
Thank you, Neha. If I can turn to Bill, do you think state responsibility is now overshadowing individual responsibility as it was envisioned by Nuremberg?
Yes, I think it probably is. I think that we've moved to a situation that has evolved, that has emerged in the last 5, 6, 7 years, where in our field, international criminal law, the center of the action has shifted from the international criminal courts to mainly to the International Court of Justice. We have other international courts who work in these areas as well, like the European Court of Human Rights. So there are these scenarios of conflicts and incompatibilities don't just arise between the two Hague courts, but there are other bodies as well where we can have conflicts, potentially. But, so far, and the Bosnia case is a good example of an informal harmonizing of the relationship between the two courts, between the two tribunals at the time, the International Criminal Tribunal for the former Yugoslavia and the International Court of Justice. We were supposed to, as you know from the program, have a judge of the International Court of Justice sitting with us, Sarah Cleveland, and sad as it is that we can't have her with us, it's probably because she's too busy to be going to conferences, I would expect, because they have so much work at the ICJ, which is a wonderful development. And it would also have been more awkward for us to talk about some of these issues if she were sitting here, and so in a way it's a relief on that point. But I see so much going on. Gerry says people on Hampstead Heath talk about international criminal justice, but there's a lot going on, mainly by public international lawyers rather than this sort of specialized group of international criminal lawyers at the International Court of Justice. And I think it's also likely to make important rulings in some of these cases more quickly than the international criminal tribunals. And I think this is a great development, personally, and we have to perhaps further explore the relationship between individuals and the state. But clearly, these crimes, particularly genocide, crime of aggression, obviously, crimes against humanity can be committed by non-state actors, more obviously, but they still have to be part of a widespread or systematic attack, and they have to be, according to Article 7.2a of the Rome Statute, pursuant to a state or organizational policy. So states play a big role here, and we need to get them there before the courts. So I think it's a very welcome and exciting development. A good friend of mine who was, he's a retired law professor now in Canada, was doing, I think, his master's degree at Cambridge in the 1970s, and in public international law. And he wanted to see the ICJ in action. So he took the train or the ferry. They didn't have the tunnel then. I don't know how he got to The Hague, but he went there and he knocked on the door. And in those days, of course, you didn't have securities and x-rays and everything to get in. You just walked in and knocked on the door, and whoever greeted him, and he said, well, I'm here to see a trial. And the guy who greeted him said, oh, we haven't had a trial here for about 4 years. You know? And of course, that was the ICJ in the doldrums, because of its, mainly because of its very miserable performance in the case filed by Liberia and Ethiopia against South Africa in 1966, which was disastrous for the court and drove people away. And then slowly the states started coming back, so that we have an institution that's never been so busy. And again, in her keynote speech yesterday, I think Sylvia, or was it Eleanor Hammarskjöld, pointed to all of the cases, the genocide cases, 4 of them. One had a brief life earlier this year, and it's over, but so that would have been the 5th, which engage a lot of states in issues of international criminal justice. But it goes beyond this because of all the interventions. And we now have about 50 states that have engaged by means of intervention in these genocide cases. In the entire history of the ICJ, until about 3 years ago, I think there had been 3 interventions. And they were by states that were concerned that, you know, a maritime boundary division might affect them, or you know, that they were going to come and get the whales in their sea or something. And this is different, because it's all, everybody's erga omnes. They're all there because they trust the court. And I think what they're saying quietly is, we don't quite trust the political organs anymore. They're not doing the job they should do. And so we're going to rely upon 15 people who are independent and impartial, and we don't exactly know the views they're going to take. We know in a few, because we have a judge who does interviews and talks about her religious views, but this is an exception rather than the majority, who are, by the way, and I'm very happy to say this, although Sarah Cleveland isn't sitting here next to me, but it's a phenomenal bench. It's a great court right now, made up of terrific judges. I think 6 of them are previously professors of international human rights law. So how good is that, you know? If you wanted good judges, where else would you go to get them but to the academic community of international legal scholars?
Thank you, Bill. Moving on to question of immunities, I think it's a natural theme to get into after discussing state and individual responsibility. Immunity used to be seen as a way of protecting diplomacy, but today it often feels like the last shield of individual accountability. Nuremberg Principle 1 proclaimed that no one stands above the law. If I may quote, "Any person who commits an act which constitutes a crime under international law is responsible, therefore, and liable to punishment." Nuremberg Principle number 3 states that the fact that a person who committed an act which constituted a crime under international law acted as head of state or responsible government official does not relieve him of responsibility under international law. If I could start with you, Gerry, on this theme, how do you think these principles fare today in the face of immunity? If you think about the arrest warrants that have been issued out against Putin, against Netanyahu recently, and it seems like there is also a double standard with how, in respect to how this arrest warrant issue is applied. Back in 2015, under al-Bashir, he tried to travel to South Africa. Western states were quite very hands-on on South Africa. You need to arrest Putin, al-Bashir. Putin tried to travel to South Africa. Eventually, South African courts decided that South Africa has a responsibility under the Rome Statute to arrest Putin in case he steps foot in South Africa. When Putin's arrest warrants came out, everybody was also very supportive of this. The arrest warrants of Netanyahu come out, and we see a change in tone. What is your view about considering Nuremberg Principle 1 and Nuremberg Principle 3 and the current situation? What is your view on this, and what does this mean for today and for the future for international criminal law?
We seem to be perpetually poised between considerations of sovereign equality and state sovereignty on one hand, and an obvious imperative to prosecute individuals who've committed crimes against humanity and as many fora as possible. And the current debates, as you know, are about the relationship between arrest warrants and interstate immunity, both of which are implicated when a head of state arrives in a state signatory to the ICC, and also between questions of functional and personal immunity. But I'm about 2 questions behind at the moment, because I've been so inspired by my colleagues on the panel that I do want to follow up a couple of the discussions, if you don't mind. And one is about something Bill said at the end about this period of judicialization. Again, I can't emphasize enough how extraordinary it is to be so focused on courts when we talk about matters of international politics and international diplomacy. This would have been entirely unfamiliar to a 19th century audience gathered in a hypothetical courtroom in Nuremberg, who simply wouldn't have understood how we could talk about war and atrocity in those particular terms. A.G.P. Taylor, the English historian, said, "States don't commit crimes, they make mistakes." States don't commit crimes, they make mistakes. And that, in a way, is a retort to the Nuremberg obsession with applying law to states rather than applying the rules or norms of diplomatic conduct to those states. So it's a remarkable transformation. Whether it's a positive transformation is an open-ended question in some ways. And I think back to the legalizations around the debate about the Iraq War in 2003, something that Robert Knox, the international law scholar, has written about. So initially there was a huge amount of enthusiasm about the fact that lawyers seemed so obviously important in 2003 to these questions, crimes of aggression, the illegal use of force. And a few of us from Oxford, Cambridge and LSE wrote a letter to The Guardian saying that without a second resolution, you'll remember there was a long discussion about that, the war, the prospective war in 2003 would be unlawful. And we were very pleased with ourselves at that point. We felt that we'd made an important statement of principle and that law had become a sort of center stage preoccupation. There were even references to taking Tony Blair to some, again, hypothetical venue in The Hague to be tried. And almost all of the protest around the Iraq War was couched in Nuremberg terms, or at least UN Charter terms. This war, 100,000 people marched in London, and the language used by the protesters and on the placards was an international legal language, or what I want to call today a Nuremberg language, and that was rather remarkable. But it had a strangely double-edged effect in that it turned out that the Blair and Bush administration and government could also use law against us. So this sort of ended for me when I heard the Prime Minister on the radio being badgered by a BBC journalist who was notoriously tough as a questioner, saying, look, the Iraq War really hasn't worked out well. It's been a strategic disaster. It's inspired more acts of terror. There are no weapons of mass destruction, and things are utterly chaotic in Iraq. And Blair turned to the interviewer and said, yes, but what you don't understand is that under international law, there were 13 resolutions that more or less told us we had to do it. So international law is very, very double-edged when it comes to these sorts of matters. And I think it's worth watching out for that as we explore the language of international law. But let me get back to the question before that, which was about collective responsibility and state responsibility, which I didn't sort of get a go at, and I have got some thoughts about that, Darleen, if you don't mind. So if I could rewrite the IMT judgment for a second here, you remember the famous quote, crimes are committed not by abstract entities but by men. I mean, perhaps we can say that these crimes are committed by abstract entities and men, and occasionally women. In other words, it's always individual responsibility and state responsibility. And this moment where we see these two idioms and the institutional infrastructure around them, the ICJ and the ICC together at the front of the public and professional mind, in some ways is just symptomatic of those shared idioms. We're in an ICJ and ICC moment, and I sort of share Bill's views on that. To a certain extent, it's simply what we have. It's an organic aspect of the way the ICC and the ICJ have been established, and we should simply accept that. We can't really here propose limits to that. This is something that's simply happened in international law, and we now have these two institutional frameworks, each dealing, in one case rather unexpectedly, with questions of aggression and genocide. And of course, there's the possibility of people mixing these things up. I heard an Australian Prime Minister, Kevin Rudd, once demanding that the Iranian president be sent to the ICJ for trial, to go back to your point about trials. So it is possible for the public, and indeed for high-level political officials, to do that. But it's always been thus. If you think back to the history of international criminal law, I mean, it begins with what you might think of as a high point of state responsibility, the reparations regime and the war guilt clause at Versailles. And that Versailles model, in a way, has continued to haunt the whole field. But, as we also know, the First World War provoked trials themselves at the German Supreme Court in Leipzig. So the 1918-19 moment is understood as a moment of collective responsibility, sanctions, a rather disastrous reparations regime, which may or may not have led to the Second World War. But for us as international criminal lawyers, it also marks the introduction of the crime of aggression into international legal semi-orthodoxy with Article 227 of the Versailles Treaty and the Leipzig trials. And one can engage in the same sort of dual analysis through the whole history of the discipline. Nuremberg is both a high point of individual responsibility, but also a moment when it was made clear that institutions can be criminally responsible and in fact can be described or characterized as criminal. A rather important insight of the tribunal here 80 years ago, and one that's slightly slipped out of the consciousness of some international lawyers and most of the public. And also, of course, Nuremberg ought to be paired with Potsdam, or the treatment of Germany after the war, which were matters of, if you like, collective responsibility. So we've always had that, and this dual idiom in relation to Russia and Ukraine is very, very familiar. Putin has committed a crime of aggression. Russia has breached the law on the use of force. This dual way of speaking about international law, as I said in my initial points, has seeped in to the popular vernacular and our professional obsessions.
Yeah, well, like Gerry, I have a lot of lists of things I want to talk about, and we have. Do you really want us to insist on the immunities point?
Yes.
Because we've been quarreling about immunities for a long time, and I think we probably attach way too much importance to it. The Bashir case consumed a huge amount of energy at the ICC. Finally, didn't really do much, and he's still there. And he's not being brought to trial. I don't know if he ever will be. The Nuremberg principles, of course, I think are also misunderstood. I often hear diplomats and journalists and everything saying, Yes, but you can have no immunity because everybody has to be held accountable, not even leaders, even heads of state. And of course, that's what the Nuremberg principle said, and it's what the International Court of Justice said in the arrest warrant case. They just said, you can't be held accountable everywhere. So, the disciplinary tribunal of the University of Nuremberg cannot try the head of state of another country for the crime of aggression. It depends on the court that you're before. And that's what the ICJ said in the arrest warrant case. I think that probably the appeals chamber of the ICJ didn't entirely confront of the ICC, I mean, in the Bashir case, the one from Jordan, didn't entirely confront it. And we're seeing that visibly now in things like the statements by a number of countries that they weren't sure that they would arrest people, well, one in particular, the N-word, as Donald Trump says, Netanyahu, that they would not arrest him if he were to set foot on their territory. To that, I think whether or not you agree with the appeals chamber decision, it's an order from the court. If you're a state party to the court, you may not like that decision, but you have to respect it. But the fact is, there appears to be an unease in many foreign ministries amongst the lawyers there and the governments that maybe the ICC went a little too far in the judgment on Jordan. And we see that in the recognition, effectively, of the immunities in the statute of this new proposed ad hoc tribunal. But we have other manifestations of it as well. So, I really was hoping, because we had a third question about genocide and the Genocide Convention. Are we getting to that? Because I don't want to lose that one. And I wanted to be the first person in the room to use the G.
I'm going to address that
okay.
to you.
The G word.
The G
and
word.
by the G word, I don't mean genocide. I mean Gaza. So.
Before we move on to the question of interpretation of the Genocide Convention, Neha, do you have anything to say on the question of immunities?
I don't want to steal Bill's thunder, so I'm going to be short. Just responding to the double standard issue, I actually don't think the ICC has helped matters. I mean, there are double standards. I'm not disagreeing with that, but I don't think the ICC has helped matters here. So if you look at the Bashir case, the appeals chamber decision, but then also the Mongolia pretrial chamber decision, there Mongolia had argued, with respect to President Putin, that it has this responsibility under customary international law, and it cannot arrest him for that reason because there's no Security Council resolution, unlike in the Bashir case. And the court just did not engage at all with the customary international law reasoning. It looked at the Rome Statute. It said, well, under the Rome Statute, this is what Article 27 says, and this is what Article 98 says. And so the court refused to engage with the customary international law argument at all. And I don't think that that's helpful, because there is actually quite a lot of evolution now in state practice. You have in Just Security, this blog, this wonderful tracker of how different states are reacting and the statements they're making with respect to Netanyahu. And you see that actually most states, yes, there's reluctance, and sometimes they're non-committal. Like the UK, for example, said, well, we're going to leave it to our courts. If he comes here, we can't prejudge what our courts will say. This is a question for our courts. So the UK has punted, as opposed to saying we're not going to arrest him. There's actually very few states that have been openly saying that we will be in trouble, we will not arrest him, or we can't arrest him. And you see it in things like flight patterns. There's now an analysis of Netanyahu's flight patterns when he goes to various destinations, and he takes longer routes to avoid countries where if he had to make an emergency landing, he might be subject to an arrest. He flies over countries where there are US military bases, so if there's an emergency landing, he can land at a US military base and not be arrested. So there is actually quite a lot of evolution in state practice, despite the reluctance of some states to arrest him, and there's an evolution in his behavior. And so I think the ICC, rather than kind of just refusing to enter into the question of what is the customary international law position, I think the ICC would have done better to actually engage with states and enter into a dialogue, as opposed to pretending that the Rome Statute is this closed framework and it doesn't need to take the evolving state practice seriously, because the evolving state practice might actually be in its favor.
Thank you, Neha. So we have less than 2 minutes, and I would like to finally discuss the interpretation of the Genocide Convention, which has been invoked a lot before the ICJ, in between ICC debates, and also very deeply politicized. In global conflicts from Myanmar to Ukraine, an open question to the panel: what does this tell us about the future of international criminal law? Is the Genocide Convention, has it always been more about interstate obligations rather than individual responsibility? Do you want to lead us with that?
Yes, sure. I should say, by the way, just to finish with the immunities issue, that I was secretly hoping they were going to give the Nobel Peace Prize to Netanyahu. On the condition that he go to Oslo to pick it up, which he would have to do. When they were drafting the Genocide Convention, there was no clarity about the extent to whether this was a convention about state responsibility for committing genocide, or whether it was actually more of a suppression convention like the ones that we've had since the 19th century, dealing with everything from human trafficking to counterfeit trafficking and counterfeit money and drugs and so on. In other words, a treaty that imposed obligations on states to repress the crime, but that wasn't really about states committing the crime. And we see that in this an enigmatic definition of genocide, Article 2 of the Convention, which is then carried over to the Rome Statute, which talks about intent and is drafted with the view to individual criminal responsibility. And so I was earlier this week in Berlin with a debate, talking with Kai Ambos, and he's got Dolus this and Dolus that, and it's all about German criminal law, very sophisticated notions, but we're really talking about state responsibility here. And so the convention wasn't designed for that, and part of the struggle is getting it to fit. And it's also about this relationship between the criminal tribunals and the ICJ. The ICJ built on the case law of the Yugoslavia Tribunal on genocide, and that tribunal, and I remember talking with judges at the time, this issue, their attitude was, well, we don't have to rule on genocide in Bosnia and Herzegovina because we convict them of crimes against humanity, and it's just as bad. And others have said that. The Yugoslavia Tribunal resisted the idea that there was a hierarchy of crimes, and others have said it. And, who would dare say in this sanctified room that crimes against humanity aren't the right label for the worst crimes that could be committed by anybody? So the ICJ had sort of adopted that view, but without the ability to fall back on saying, well, maybe it's not genocide, it's crimes against humanity. They couldn't do that, but because they were following the Yugoslavia Tribunal's case law, they threw the cases out. And I remember when the Croatia decision was issued in 2015 thinking, this is it for the Genocide Convention. It's dead. It's dead. It's not going anywhere at the ICJ because of this strict interpretation that they've inherited from the Yugoslavia Tribunal. But I don't believe that today, and I see more than 50 states who are calling upon the ICJ to do more with this historic instrument. Historic, using language that wasn't fit for purpose. It doesn't entirely fit, but they're saying do more with it. And that's what these interventions are doing, and they're extremely important. Now, someone alluded to the fact that not Tony Blair, but Keir Starmer in the UK says, well, we can't rule on genocide in Gaza because we have to wait for a court to decide this. And Macron has said the same thing. I don't know if the German Chancellor has said something similar, but it's a kind of a mantra that we're hearing now. And it's so clearly wrong, and it's in contradiction with what several of these states have themselves said in interventions in things like the Ukraine case, where they said, if you think genocide might be taking place, you have a duty to go to the organs of the United Nations, the political organs, and address the question. They don't say anywhere in those interventions, you can't say it's genocide until we have a judgment of a court. So this is just completely wrong. There's something else that they say there's one of the richest of the interventions is the one in the Myanmar case by Canada, France, Britain, Denmark, Netherlands, I'm forgetting one country. Germany, yeah, Germany. Germany signed it too. And in there's a paragraph towards the end, paragraph number 76, where they say, when we're trying to prove, when the court is going to examine proof of genocidal intent, it should pay particular attention to reports by commissions of inquiry. Commissions of inquiry set up by the United Nations, fact-finding missions by the United Nations, which are highly credible, independent, and so on. It's a very, of course, they didn't have in mind the report that was issued last month by the Commission of Inquiry into Palestine, but it applies. They were thinking of the ones dealing with Myanmar, but they say this in a very general sense. And that report, just was very clear and unequivocal about the situation in Gaza. And the central author, in a way, the chairman of it, is one of us, known to many people in this room, Navi Pillay, the first judge since the 1990s on the Rwanda tribunal, presided. She was one of the 3 members of the bench in the first genocide case in modern times, the Akayesu case, and then she was elected to the ICC, and then she was the High Commissioner for Human Rights. Is there anybody on the planet better qualified to rule on genocide than she is? So I think that Commission of Inquiry report also is extremely important, and in effect, we're not going to have a judgment of the ICJ even in the Myanmar case for perhaps the next 2 years. So I think it stands as it's the benchmark now on the subject. The idea that we can't say it, we have to wait until a court pronounces. It's just wrong. We have this Commission of Inquiry report, amongst other materials, but it's the key one. Thank you for giving me the floor for that.
Thank you, Bill. Before we take any questions in person and online, Neha, Gerry, do you have anything else to add on this? Okay, then we can proceed to take questions. We have 2 microphones on each side of the room, and you can also scan a QR code on the back of your brochure if you want to submit questions online. Any questions from the room? I will then take some questions that you have received online. This first question is to all the panelists. Doesn't conforming with states' responsibility mean abandoning the purpose of international criminal law and giving up on it as well? Who would like to take this first?
I didn't entirely understand the question, but I'll answer it anyway. First of all, speaking as a long-term member of the British Labour Party, I was very struck by your Freudian slip there, Bill, mistaking Keir Starmer for Tony Blair. I wanted to say something about the Genocide Convention, but because I'm on a panel with one of the world's experts on that subject, I'm not going to talk about the convention itself, but go back to, I suppose, one of my preoccupations, which is the way, I know this speaks to the Nuremberg Academy, the way international law is understood in the public mind, because I think to a certain extent what's happening out there when people debate genocide is that there are 3, I'll say, images of genocide in circulation in the media, around dinner parties, at protests, and between peoples who feel themselves to be in a sort of existential conflict. One of them is derived from the Genocide Convention, which itself, of course, is at least somewhat contested. I mean, as soon as we think about something like intent. We're in the weeds of a discussion about whether intent is something that sits in the human mind as a form of mens rea or as something to be inferred from circumstantial evidence around it. We've been through all that in the jurisprudence of the ICTY and so on. But the Genocide Convention, nevertheless, contains a definition of genocide, which to a certain extent is both broader and narrower than some of the images of genocide circulating amongst the public. So, for example, it's broader than the second image, which is an image derived from the events that this court was engaged in, though, of course, the crime of aggression was regarded as much more important than the question of the Holocaust for the Nuremberg court. But namely, the genocide inflicted on the Jewish peoples of Europe. And I think that image, the image of the Holocaust, haunts public discourse around the question of what constitutes a genocide. When British soldiers were accused of committing war crimes in Iraq, I remember reading in the Daily Telegraph that was an impossibility because these crimes were nothing like the crimes committed by the Nazis against European populations between 1939 and 1945. So this second image of the genocide as a Holocaust is something that people hold on to quite dearly out there in the public. And then there's a third idea, which is much more visceral, that people somehow see genocide with their own eyes, that they look at the footage of our TV reporting, such as it is, of, say, events in Gaza, and they see what they think must mean genocide. And while we could adjudicate those three claims, I also think it might be useful just to understand that people sincerely hold those three views of what genocide involves and how it should be understood and how it should be discussed as part of the public discourse.
Thank you, Gerry.
So if I can just continue that, I think there's a fourth image, actually.
There's always a fourth
There's
image.
always a fourth image. And I think that fourth image, which probably was not there in the Genocide Convention because of this Holocaust imagination, is one of slow violence, genocide through slow violence. And I think because of the situation in Gaza and because of the public debate surrounding Gaza, I think what we see is an opening up of the possibility of seeing mass atrocity as not something, including genocide, as not something that happens in this violent, quick fashion, but something that takes place, not over years, but sometimes over decades. And so I think there is a change in how the public talks about genocide in lots of ways that are not necessarily part of the original imagination of the Genocide Convention. And I actually think there's something productive, and as you said, in keeping those variations of genocide open, not for the purposes of the court, not for the purposes of adjudication when it comes to commissions of inquiry or formal institutions, but I think it is really productive to keep imaginations of slow violence as part of how we think about mass atrocity in general, whether it comes to state responsibility or individual responsibility.
Thank you. We have two questions. I don't know who was first.
Ladies first.
Okay, ladies first. If you can introduce yourself and tell us who you're working with and who your question is addressed to. Thank you.
I don't know if this is on, but it's fine. Right. Thanks, everyone. My name is Rashmi Raman. I work at the National University of Singapore at the Center for International Law. My question is to anyone in the panel that would like to accept the provocation. And it comes from many of the ideas, threads of many of the ideas that I've heard spun out today. Specifically, it relates to Gerry's work on the sentimental life of the law. I can't get over that. I've been reading it ever since he published it. And to think about the mundane everydayness with which big, weighty questions like genocide in Gaza are being discussed today makes me wonder whether this new Nuremberg moment that one of the speakers pointed to yesterday, they said, we need a new Nuremberg moment. So on the one side, we have this kind of urgency to rediscover what the new Nuremberg moment might be, to seize the momentum. On the other hand, the episodic violence of terrible crimes, like genocide and crimes against humanity, to oversimplify, over the last 100 years, has become less about episodic acts of violence and more about everyday, long and slow kind of violence. So I call this, in something that I wrote, a move from chronos to kairos, which is, to borrow from the Greek, it's going into a long form of violence that normalizes it. And far from being enthused by the fact that people on the park are discussing in an ordinary way crimes against humanity and war crimes, it makes me wonder whether the drama or the performative element in state responsibility, big theaters like this historic courtroom, instead of marking the register of the dramatic performance, they now don't serve that anymore. They are just another venue for us to discuss how helpless we are in the face of state-perpetrated violence, mistakes, whatever you call them. But the idea is that violence is becoming more ordinary, and the drama and the performance of it is gone, which brings us back to the melancholia, the sentimental yearning of international law, the idea that all of us are consumed with this idea of a self-fulfilling virtue of international law, which is something it promises itself. And in the face of Gaza, Myanmar, Ukraine, we now have to come up with a system that judges those states, but also doesn't look too good while doing it. So, yeah, I invite anyone to respond. Thanks.
Thank you very much. Perhaps we can take one more question, and then we can go back to the panelists for a response.
Thank you very much. My name is James Onolaja. I'm a barrister from the UK. Can I thank you very much to the panel for this excellent contribution all round, and I struggled to actually find the particular one of the arrays of topics to touch upon, from, of course, the expensive moot court in relation to Ukraine to the effective double-edged sword of international law. But I chose perhaps to focus in on trying to consider, in fact, the foundations of Nuremberg Tribunal and the Nuremberg Principles, leading to the current bastion that is the International Criminal Court, and the challenges that it now faces, some may argue, as a result of attempting to enforce and push forward Nuremberg principles. And the question I ask is that perhaps, do you foresee an area in which there might have been a misinterpretation of, in fact, what has happened here in Nuremberg, which has led to a situation whereby the International Criminal Court has, through its rulings on sovereign immunities of heads of state, have now perhaps squeezed itself into a corner, which it now has to try to find a way out. I ask this question really based on this. The judgment, the appeal court's judgment in the al-Bashir ruling concluded that, in fact, there's never been a principle of immunities for sitting heads of state. Looking through the history and the case law, and it started effectively by looking at the fact that state officials in this courtroom were put to trial, were put on trial and convicted. And it went through Milosevic, it went through, of course, to Charles Taylor. And they came to that conclusion that there's never been an issue of immunities for heads of state before international courts. But some may argue that, in fact, none of those examples relate to sitting heads of state. The individuals who were put to trial in this building, in this courtroom, were removed from their offices at the time in which they were put to trial. And that applies to Milosevic, and it applies as well to, of course, Charles Taylor. And perhaps, in fact, what the case law suggests is that, of course, you can indeed put to trial heads of state once they are removed. But it doesn't stop the court from bringing proceedings, bringing arrest warrants, and waiting for them to, in fact, leave office before you put them to trial. And perhaps it might be a way out for the court in reinterpreting its own ruling in due course.
Thank you very much for the question. Because of maybe one last question, and then we can proceed to answer them because of time constraints.
Good morning, dear colleagues. My name is Olena Chernova. I am a lawyer from Ukraine. And of course, I can stand to pose a question to William Schabas. My question about difference between Gaza and Mariupol, the genocide, I believe, committed in Ukraine as well. And you very believe that genocide has been committed in Gaza, but you deny that genocide not happened in Ukraine, especially in Mariupol. What is the difference between two countries and of your point of view? Thank you. This is my question.
Thank you very much. Gerry, do you want to take the first question?
Well, I'll be very, very brief because I know we've only got 9 minutes left. So I've got 3 minutes on the history of international criminal law here, but I'll give you a capsule account. I think we're in a Nuremberg moment, a new Nuremberg moment, but also, and I took this from the speeches last night at that very moving ceremony in the town hall. That we're also in an anti-Nuremberg moment. And I think we have to be alert to that. There was something about that car crash moment, to go back to the Ukrainian question, in the White House a few months ago, between Zelensky and J.D. Vance, really, in which two images of international criminal law or international relations were in competition, one of which was Zelensky's, a sort of belief that historical responsibility matters in diplomatic settlements, but the other, which is both familiar and maybe insidious, was that put by J.D. Vance and indeed the Trump administration, which really articulates a vision of internationalism in which that doesn't matter, in which the suspicion is of an over-allocation of historical responsibility in international justice in favor of the art of the deal.
Thank you, Gerry. Neha, would you like to take the second question or add on the first, or both?
No, I'll be brief as well. So the 30-second answer is a 3-minute answer. I think on the immunities question, like one thing that the ICC has emphasized, but perhaps not articulated clearly, is just how much it matters, the fact that it's an international court. Like, it's not enough to just assert that you're an international court, and therefore the practice on interstate immunity does not apply to you the same way as it does to between states. And the ICC has said, well, you know, in interstate matters, the development of the doctrine of immunity came about because of the possibility of the abuse of discretion, prosecutorial discretion, but we're an impartial court, and so we're somehow above interstate politics, and so the question of immunity does not apply. So you see the court doubling down on itself as a vindicator, again, of community interests, which is perhaps part of the legacy of Nuremberg, where you vindicate community interests. But at the same time, just as we saw in Nuremberg, this is not a response that is satisfactory, where you put yourself in the position of being the trustee of the international community, and you have to do more to convince your audience that there is really an international community out there, and somehow you have this institution that's vindicating it. So I think the immunities question is about doctrine, as you pointed out, but it's also about the position of the court as an institution and where an international court sits, as opposed to where domestic courts sit in relationship to states.
Neha, Bill?
We could have a whole conference on immunities and address all those issues you raised, James, in your comment or your question. I have a favorite provision in the Hague Conventions, one of 1899 and 1907, that deals with what we call the immunity of the parlementaire. We use the word parlementaire in the English as well, and the parlementaire is the peace negotiator. And so this is a very useful and important form of immunity. It's not the same as head of state immunity, but it's the idea that it reminds us that some immunities serve a very important function, because if there's a war going on, we want the leaders of both sides to be able to meet somewhere safe. Safe in the sense that they're not worried about being killed or attacked. The immunity, it just as a little anecdote on the side, the immunity is not only for the parlementaire, but those who accompany the parlementaire, in particular the drummer and the bugler. So we don't see drummers and buglers very much these days in Geneva, but the fact is, we couldn't, Putin wouldn't go to Geneva for negotiating peace in Ukraine. Netanyahu wouldn't go to Geneva. The leaders of the Hamas wouldn't go to Geneva to negotiate peace, or the other likely places. So we're kind of condemned to, where can they go where they'll be safe? Cairo, I guess, or Qatar, or something. But this circle is going to narrow, and it's important that we respect that. That's a separate issue, of course, from the issue of the head of state immunities. But it's just it's become a total dirty word, immunity, and we sometimes lose sight of the fact that there are some very useful and important functions that it protects. There was a question for me about Mariupol and Ukraine, and what's the difference between Mariupol and Gaza? Listen, Navi Pillay and her commission wrote 70-odd pages trying to lay out the case for genocide in Gaza. It's a long discussion, if you will, if we want to compare the two situations, and I don't want to do that here. I frequently get asked from various quarters whether this or that situation is a genocide, and I used to sort of enjoy the idea of being able to pontificate a bit and say, no, it isn't, or yes, usually it was no, occasionally, yes, it is, and I don't like doing that. I've stopped doing it. I've learned the hard way. The correct answer should be a legal one, which is there's a very strong case, or there's a very weak case, or there's a good case, or a reasonable case, or not much evidence, or a lot of evidence. I think there's a lot of evidence in Gaza. I think there's less evidence in Ukraine, and there are other factors that point to that. Ukraine is free to go. They've got an open door at the ICJ. They can get Russia for committing genocide if they can prove it, and they have a lot of very expensive, high-priced lawyers who are working for them. They could do it, and they haven't done it. Maybe they will at some point. But I think they probably look at the evidence as well and say, do we really have a good chance at proving this? And of course, we go to the frivolous end of the spectrum as well. Donald Trump, in the presence of the president of South Africa, dared to say that South Africa is committing genocide against, this is the extreme end of the spectrum. Am I a denier for saying I think that's a ludicrous proposal? An insulting one too. But this is it, and the word is used, and Gerry spoke about the different uses of the word and the different contexts. And I don't think there's anything wrong with people using it in different contexts. It's not as if the international lawyer has to come and say, well, no, you can't say genocide because that's not consistent with Article 2 of the Genocide Convention. It's like torture. We use the word torture in all kinds of circumstances, and we don't just say, well, no, that's not torture according to the European Court of Human Rights law, case law on Article 3 of the European Convention. These are words in the language that people can use in different contexts, and the challenge only sometimes is to realize that it's being used in a more of a political, sometimes a demagogic context. You may remember that when the conflict in Ukraine began in 2022, President Biden made a statement saying, "It looks like genocide to me." But this was the sort of shock and everything. He clearly was not he did not have a sophisticated grasp of international criminal law, to put it politely. And the lawyers working for him, including our friend Beth Van Skak, who was then the person responsible for war crimes, gave very cagey comments on it along the lines of, well, yes, the president made this statement and we'll see how it develops or something, and didn't endorse the statement by President Biden. And there were Russian diplomats who made the same allegations, of course, against Ukraine, and both of them were kind of in some ways far-fetched.
So much, Bill. We have 30 seconds, and I think at this time we will. Do we have more questions? No, we have not. We have more questions, but I have been informed that we really have to stop because of time. So feel free to continue discussions over coffee break. I would like to thank our panelists, Gerry, Neha, and of course Bill, for this very thoughtful and inspiring contribution. So thank you so much.